So good morning to all participants. This is CMA Deepika B. Prasad, partner, AAA Insolvency Professionals. It is wonderful to have you all today on such a wonderful day when we are just going to enter 2023. And we'll study a very important aspect today, which is a Supreme Court judgment on Sudaresh Bhatt versus ABG Shipyard. I'll just give a brief about myself. Just give me one sec. Let me share the file. Yeah, so I'll just give you a little brief about myself. I'm Deepika B. Prasad, partner, AAA Insolvency Professionals. I have done up till now 13 assignments, which include as IRP, RP, and liquidator. And I've just been appointed RP for 8 personal insolvency cases, not yet been admitted, although appointed RP, waiting in the process. So it is very nice to have today this opportunity to interact with all friends. So I will start with this SC case analysis. We have with us Advocate Shalya Agarwal, who will be supporting me in this presentation. Shalya, you want to say something?
Yeah, a very good morning to all the participants. And it's a pleasure on this special day, that is the last day of the year, to have such a wonderful topic with us, wherein we all can collectively learn this judgment. So, ma'am, I think we can start now.
So I hope everyone can see the slide. So we are here today to discuss the SC case analysis in the matter of Sudaresh Bhatt, RP of ABG Shipyard. We'll just quickly go through the facts of the case. The workmen and employees of Messrs. ABG Shipyard Limited working at Dahej and Mumbai had filed against the order passed by Hon'ble NC LT Ahmedabad bench dated 25th of April 19, not granting any relief to them with regard to their claim relating to salary, which they claimed for the period involving CIRP process and the prior period. So this was by the workmen and employees of ABG Shipyard at Dahej and Mumbai. Just a little bit about ABG Shipyard. The corporate debtor ABG Shipyard was a private sector shipbuilding yard, and it had its manufacturing activities at Dahej Yard and Surat Yard in Gujarat, having its corporate office at Mumbai. And prior to the initiation of the CIRP, the corporate debtor had about 562 workmen and 93 employees at Dahej, 291 workmen and 99 employees at Surat, and 101 employees at its Mumbai head office. The appellants here are 272 employees and workmen employed at Mumbai head office and Dahej yard of the CD. None of the 201 employees and workmen in Surat yard are appellants. On 23rd of October 2017, a company application number 348 of 2017 was filed before the adjudicating authority, praying to direct the RP to make payment to the employees and the workmen. On 9th of March 2018, the appellants filed company application number 78 of 2018 in company application number 348 before the AA, praying to direct the RP to utilize the amount of rupees 9,75,33,236 to be received from the Indian Coast Guard solely for employees and workmen. While order dated 25th of April 18, in company application number 78, while 348 was still pending, the AA directed the RP to deposit 2,75 lakhs in the registry of the AA, subject to the outcome of 348. In the meantime, there was a fourth COC held on 8th of December 2017, in which this issue with respect to the payment of salaries and wages was discussed. However, this was not resolved, and thereafter the appellants went further and filed the aforesaid IA 78, in which the AA directed to deposit 2.75 crores out of the total amount of 9.75 with the registry of the NCLT towards disbursement of the outstanding salaries, wages to the appellants, subject to the final outcome of 348, and therefore 78 was disposed of. Since no agreed resolution plan could be adopted of the corporate debtor, the RP filed IA praying for an order of liquidation of CD. Further, the AA by order dated 25th of April 19, after deciding the application of the appellants, that is number 348, passed an order of liquidation of the CD and appointed the RP as the liquidator of the CD. While passing the order of liquidation, the AA also disposed of the company application number 348 in view of the order passed in the company application number 78, by which the AA had earlier directed to deposit 2.75 crores towards the dues of the appellants, which was as such the subject to the final outcome of the application number 348. Therefore, as such, while disposing of the company application number 348, they did not grant any relief claimed by the appellants. So two applications, 348 and 78, finally the relief was not granted to 272 workers and employees working at Dahej Yard and Mumbai head office for their claim relating to salary for the period involving CIRP and prior period. Further feeling aggrieved and dissatisfied, the appellants, they went ahead and preferred a company appeal number 605 before the appellate tribunal. The appellant tribunal further disposed of the said appeal, declining to interfere with the order passed by the AA. However, it allowed the appellants 272 workmen and employees to file their individual claims before the liquidator, who, after going through the record and taking into consideration the pleadings made by the workmen, will determine the claim. Just one second. Excuse me. The appellant tribunal has also further observed that if the claim of one or the other workmen or employee is rejected, it will be open to them to move before the AA, which may decide the same in accordance with the law. The appellant tribunal further also observed that so far as the gratuity and provident fund are concerned, the same cannot be treated to be the assets of the CD, and they are to be dispersed amongst the employees and workmen who are entitled for the same. Further feeling aggrieved and dissatisfied with this order, the workmen and the employees of the CD preferred an appeal before the Honorable Supreme Court. Now we go ahead to discuss what happened, what were the arguments by the advocate of the appellants as well as by the advocate of the liquidator, and further what was the judgment given by the Honorable Supreme Court. So the advocate for the appellants was Mr. Shobha Ramamurthy. Appearing on behalf of the appellants, she submitted that in the present case, the respective appellants are the workmen and employees 272 working at Dahej Yard and Mumbai head office of the CD, and the CIRP period commenced from 1st of August 17 and ended on 25th of April 2019. And for the entire period of 20 months and 25 days, the respective employees and workmen were on the payrolls of the CD. Further, the RP did not terminate the employment contracts or retrench or lay off the workmen. On the other hand, the RP further issued instructions dated 4th of September 17 to all the employees and workmen to report to him and follow his instructions. On 15th of November 2017, RP issued an email to HR department of CD instructing strictly not to relieve or permit resignation of any employee or workman without written approval. In the present case, the CD was managed as a going concern in accordance with section 21 of the IB code. This is as per the advocate of the workman, that even the proposal to suspend operations at Dahej Yard and provide workmen with paid leave was rejected by the COC for lack of majority. Therefore, when the CD was managed as a going concern, which is mandatory under section 19 of the IB code, and when the operations at Dahej Yard were not suspended, the workmen and employees at Dahej Yard are entitled to at least the wages and salaries during the CIRP period. That irrespective of whether the wages or salaries for the period during CIRP are to be qualified as CIRP cost or not, whether Provident Fund, Gratuity and Pension Fund are to be paid to the workmen and employees at Dahej Yard under section 36(4) of the IB code in priority of other dues, which are still not paid till date. Just I'll give a brief before we move any further that what this case is all about, whether the workers appellants are claiming actually that the salaries and wages which are due to them must be paid to them under section 53(1)(a), which covers the IRP costs in full, which would actually make that they would get their salaries in full. Whereas the liquidator is bringing up that they cannot be paid under 53(1)(a), and they should be paid under 53(1)(b) and C, wherein they will get a proportionate share and not in full. So whether they would be covered as CIRP costs in full, or whether they would be covered under section 53(1)(b) or C, is what the whole case is all about, and how the SC, Honorable SC, has given the judgment. So the advocate of the appellant goes further in saying that in the present case, throughout the CIRP period, the employees and the workmen of Dahej were asked to assemble at the ABG enclave and sign the attendance register, since transportation to the yard was discontinued by the RP. And the learned counsel further brought about that she has relied upon some documents from the paper book as well as the rejoinder affidavit in respect of proof of work done by the respective employees and workmen during the CIRP period. Further, that all the claims by employees and workmen in Form E with the liquidator have been verified, that the verified and admitted claims of the employees and workmen of CD for CIRP period on the basis of the records available have also been uploaded by the RP and the liquidator on 24th of December 2020 on the official website of the CD as per regulations. That therefore further verification in respect of the claims of the appellants based on their actual attendance is vexatious. Further, the arguments went about to say that she argued that based on the relevant provisions of the IB code in support of her submission, that the workmen and employees of the Dahej Yard and Mumbai head office are at least entitled to the wages and salaries during the period of CIRP and are also entitled to the amount due and payable towards provident fund, gratuity, and pension. So the learned counsel has relied upon sections 336, section 513, section 514, 523, section 17, section 18, section 19, 20, 25, 33(7), 36(4), and 53 of the IB code. We'll come to a brief discussion on all the aspects. That the objective of the IB code is for maximizing the value of the assets of the CD so that they are efficiently run as a going concern. He has further placed his reliance on the decision of the court in the case of Swiss Ribbons versus Union of India and in the case of Gujarat Urja Vikas Nigam versus Amit Gupta. That even under section 21 of the IB code, the RP is mandated to manage the operations of the CD as a going concern. That for this purpose, he is vested with the authority to issue instructions to the personnel of the CD, as may be necessary for keeping the CD as a going concern. Section 513 further defines insolvency resolution process costs, which means any costs incurred by the RP in running the business of the CD as a going concern, and any other costs as may be specified by the IBBI. That in the present case, the liquidator had clearly provided the costs on account of employees and workmen under the head other services in a running business in forms 1, 2, and 3 submitted by the RP with respect to the CIRP costs. So she's saying that further all these costs have been uploaded by the RP in forms 1, 2, and 3 as per the IBBI, and therefore the salaries and wages and the dues payable to the employees and workmen during the CIRP period will be qualified as CIRP costs under section 513 of the IB code and are liable to be dispersed even prior to the amount distributed under section 53 of the IB code. She went on to bring about that even otherwise the provident fund, gratuity fund, and pension fund amounts remain outside the liquidation under section 36(4) of the IB code. That the obligation to pay the provident fund, gratuity fund would soon arise as soon as the employees and workmen are deemed to have been discharged under section 33(7) of the IB code. That even the workmen and employees are required to be paid the wages and salaries for the pre-CIRP period as per the priorities mentioned in section 53 of the IB code. It is further submitted that on behalf of the appellants, that the salaries and wages payable to workmen and employees of the CIRP period are a component of the resolution professional costs, and therefore the CIRP period salaries and wages payable to the respective workmen are to be paid first and not paid pari passu in terms of section 53(1)(b) and C of the IB code. That even the workmen dues is explained in explanation 2 to section 53 of the code as the term having the same meaning as assigned to it in section 326 of the Companies Act. That section 327 of the Companies Act provides for preferential payments upon winding up of the company and lists the component of the wages or salary dues and salary dues payable to an employee under clauses B, C, E, and F under subclause 1. Thus, on a combined reading of the provisions of section 326 and 327 of the Companies Act, it is clear that the workman's dues and employees' dues are comprised of several components, including wages or salaries, holiday remuneration, sums due from the Provident Fund, Pension Fund, and the Gratuity Fund. As observed by this court in the case of Swiss Ribbons, the cost and expenses of the RP or liquidator are to be given preferential treatment by accepting them from the pari passu principle. And that 2.75 crores are earmarked and kept apart towards the dues of the workmen and employees. Therefore, the said sum of rupees 2.75 crores, which is deposited for the benefit of the workmen or employees, is liable to be disbursed in terms of section 53(1)(a), read with section 513(c) of the IB Code. And that the amount in the sum of rupees 16.8 crores payable towards the Provident Fund, gratuity, and pension in terms of section 36(4) to all the employees and workmen of the CD, including the appellants, and therefore is required to pay it in priority over disbursements to be made under section 53(1)(b) and C. So relying on the above submissions, she prayed to allow the appeal. Now, the arguments by the advocate of the liquidator. So this appeal was opposed by Shri Nakul Diwan, who was the senior advocate appearing on behalf of liquidator of the CD. He, while appearing on behalf of the liquidator of the CD, he has vehemently submitted that the wages and salaries claimed by the appellants who have done no work during the CIRP period and have not assisted the RP or liquidator during the CIRP would not fall within the parameters of CIRP costs within the definition of section 513(c) of the IB Code. Further, that only 8 employees at the Mumbai location for 8 months during the CIRP and workmen and employees from Surat from August 2017 to October 2017 assisted the RP in providing services required under the CIRP process. So the advocate here is trying to bring about the most important point, that whether the employees who have actually worked at the CIRP period are supposed to be getting the salaries and wages for the CIRP process under section 53(1)(a), or whether all of the workmen and employees would be getting those salaries. So he's trying to bring about that although they have been there, but they are not been working during the CIRP period. The remaining employees and workmen, including the appellants herein, were not required and did not perform any services to run the CD during the CIRP period. Therefore, the COC of the CD rightly did not approve any payments to the appellants as part of the CIRP costs. We can again, bring about here that it is not just that they would have worked. It is also the 53(1)(a), the CIRP costs cover only the costs which are further ratified and approved by the COC. So this aspect also has been brought about here, that the COC of the corporate debtor did not approve any payments to the appellants as part of the CIRP costs. Further, that the wages and salaries of the appellants, workmen and employees of the CD would fall under section 53(1)(b) and C of the IB Code. That as per section 513(c) of the IB Code, read with regulations 31 and 33, cost incurred by the RP in running the business of the CD is required to be ratified by the COC for it to be classified as CIRP costs. That only the costs for those employees who have assisted the RP during the CIRP period have been approved by the COC in the first COC meeting held on 4th of September 17. That therefore no other costs can be classified as CIRP costs except unless it is ratified by the COC. And that the remaining dues of the workmen will form part of the dues falling under section 53(1)(b) of the code, which is clearly bringing about that the payments to be made to these workmen shall be pari passu along with the secured creditors as per section 53(1)(a). That in the meetings of the COC held periodically right from the first meeting to fourth meeting, it was specifically recorded that the Dahej shipyard is not operational and that the CD is not in a position to pay the salaries of the workmen and employees due to the paucity of funds, since the CD was not a going concern, and did not have a running business. Shalia, please, can you take up this slide?
So the counsel for the liquidator continued to argue that since the main business of corporate debtor was shipbuilding and ship repairing, which was carried out at its yard at Surat and Dahej. So the counsel for liquidator vehemently argued that since the Dahej yard was not operational since 2015 and yard at Surat was closed in October 17, there cannot be any instance which was claimed by the advocate for the appellants that it was a going concern. So the counsel for liquidator argued that since the yards were closed, it cannot be said that the company was a going concern. And therefore, all the employees would be required to be treated that they have assisted the RP to run the corporate debtor as a going concern. He further argued that there is no evidence given by the employees of Workmen that suggests that they have actually worked during the CIRP period. Further, he argued that the appellate tribunal, the Honorable NCLAT, had rightly observed that the respective Workmen employees can at least have to prove their claims before the RP liquidator by submitting their respective claims. So if we recall, when the Honorable NCLAT was dismissing their appeal, the NCLAT had given an observation that the employees and workmen are at liberty to file their individual claims with the liquidator along with the documents in support to show that they were actually working, and thereafter that will be verified. Going forward, therefore, the appellate tribunal has rightly not interfered with the order passed by the adjudicating authority in not passing any order in favor of the workmen and employees.
Yeah, thank you, Shalia. So that the main business of the CD was shipbuilding. I'm sorry. Yeah. Further, it was brought about by the advocate that Section 53 of the IB Code sets out the waterfall mechanism in terms of which the dues of the creditors are paid, that even the operational creditors fall sixth in line after payment of the CIRP dues and the dues of the secured creditors, etc., that even after the CD goes into liquidation in terms of Section 33 of the IB Code, the dues of the employees and workmen being operational creditors would be paid in last in terms of the waterfall mechanism of Section 53(1)(f) of the IB Code. It is therefore submitted that the respective appellants, workmen and employees are not entitled to any wages or salaries for the period during CIRP as CIRP costs as claimed by them. Shri Nakul Dhawan went ahead to bring about that RP or liquidator has further submitted that the costs incurred during the CIRP period by the CD or RP will qualify as CIRP costs only with respect to costs incurred by the RP towards running the company as a going concern under Section 513C of the IB Code, and in a case where the same has been approved by the COC. So two requirements. One is that they have actually worked and while the company was a going concern, and it has been approved by the COC under regulations 31 and 33 of the CIRP regulations. That in the present case, the CD is neither a going concern nor the RP has incurred any costs. Therefore, the wages and salaries of the workmen and employees at the Dahej yard cannot be included in the CIRP costs. That after the commencement of the CIRP, workmen and employees dues, which are outstanding as on the date of the CIRP, are treated as operational creditors in terms of Section 520 and 521 of the IB Code. And that in terms of Section 32B of the IB Code, the amount payable to the operational creditors by a prospective resolution applicant shall not be less than the amount to be paid to such creditors in the event of a liquidation of the CD under Section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of Section 53, whichever is higher. So it was further submitted that it is only few of the Surat workmen and employees and 8 Mumbai employees who have rendered services during the CIRP period to assess the RP to complete the CIRP process, whose dues would be treated as CIRP costs. Otherwise, all the dues of the workmen and employee which have accrued prior to the CIRP period would be paid in terms of Section 53(1)(f) of the IB Code, both during the CIRP and during the liquidation. It was further submitted that the liquidator has accepted the claim filed by the workmen and employees. However, the said claims filed cannot be considered as CIRP costs and cannot be paid in priority to all the other claims. The treatment of the said claims of the workmen and employees have to be treated in accordance with the provisions of section 53(1)(b) and 53(1)(c) of the IB Code, respectively, as applicable and not as CIRP costs. Further, in the present case, the appellants, who are the workmen at Dahej Yard and employees at Mumbai head office, did not help to maintain the CD as a going concern, since the CD was never a going concern and that the Dahej Yard was not in operation since June 2015, and the operations at the Surat Shipyard were completely shut from October 2017. Therefore, the appellants, who are workmen of the Dahej Yard and 17 employees of the Mumbai head office, cannot claim any amounts towards wages and salaries for the CIRP period, since no work or services were rendered by them, except for the critical Mumbai employees whose salaries were ratified by the COC during the first COC meeting. Making the above submissions, it was submitted that the wages and salaries of the workmen and employees at Dahej Yard and employees at the Mumbai head office, except for those who work during the CIRP period, cannot be included or considered as CIRP costs, and therefore they have to be paid as per the waterfall mechanism mentioned in sections 53(1)(b) and (c) of the IB Code. Therefore, the respective workmen at Dahej and some of the employees at Mumbai were required to submit their individual claims, which have to be established before the RP or the liquidator, that in fact they have worked during the CIRP period. The appellant tribunal has rightly observed that the respective workmen or employees have to submit their claim before the RP or liquidator, further, who will verify whether the CD was a going concern during the CIRP period and whether in fact the concerned workmen or employees actually worked during the CIRP period or not. Against the backdrop of these arguments given by the appellants as well as by the advocate of the liquidator, the judgment was delivered by the Honorable Supreme Court. It went on like this, that we have heard the learned counsel for respective parties at length, and the issue before this court is with respect to the wages and salaries of the workmen or employees during the CIRP period and the amount due and payable to the respective workmen and employees towards pension fund, gratuity fund, and provident fund. So two issues. Number one, whether these costs would form part of the CIRP cost, and whether the funds available with respect to pension fund, gratuity fund, and provident fund would form part of this, or they would be available for the workmen and employees. While considering the aforesaid claims, the legislative history and the relevant provisions of the IB Code are to be referred to. We come to the relevant provisions of the IBC. Section 336 defines workmen shall have the same meaning as assigned to it in clause S of section 2 of the Industrial Disputes Act. Further, section 513 defines the insolvency resolution process costs to include the amount of any interim finance and the costs incurred in raising such finance, the fees payable to any person acting as the RP, any costs incurred by the RP in running the business of the CD as a going concern. So this is the important provision which says that 513 includes any costs incurred by the RP in running the business of the CD as a going concern, any costs incurred at the expense of the government to facilitate the insolvency resolution process, and any other costs as may be specified by the board. Section 514 defines insolvency resolution process period to mean the period of 180 days beginning from the insolvency commencement date and ending on 180th day. Section 17 further defines the management of affairs of the CD by the IRP. We will just quickly go through this. From the date of the appointment of the IRP, the management of the affairs shall vest in the IRP. The powers of the board of directors or the partners, as the case may be, shall stand suspended and be exercised by the IRP, and the officers and managers would report to the IRP, and the financial institutions maintaining accounts of the CD shall act on the instructions of the IRP in relation to such accounts and furnish all information relating to the CD available with them to the IRP. The IRP is vested with the management of the CD and shall act and execute in the name and on behalf of the CD, take actions in the manner and subject to such restrictions as may be specified by the board, and have the authority to access the electronic records of the CD from information utility having financial information of the CD, have the authority to access the books of account, records, and other relevant documents of the CD, available with government authorities, statutory auditors, accountants, and such other persons, be responsible for complying with the requirements under any law for the time being in force on behalf of the CD. We further go on to just having a brief look at section 20, which talks about the management of the operations of CD as a going concern. The IRP shall make every endeavor to protect and preserve the value of the property of the CD and manage the operations of the CD as a going concern. For the purposes of subsection 1, the IRP shall have the authority to appoint accountants, legal or other professionals to enter into contracts on behalf of the CD, to raise interim finance, provided that no security interest shall be created over an encumbered property of the CD without the prior consent of the creditors whose debt is secured over such encumbered property, provided that no prior consent of the CD of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt, to issue instructions to personnel of the CD as may be necessary for keeping the CD as a going concern, and to take all such actions as are necessary to keep the CD as a going concern. Shall I please cover this section?
So section 25 of the code tells us the duties of the resolution professional. So first of all, the major duty of the RP is to protect and preserve the assets of the corporate debtor. Next, the resolution professional shall undertake the actions. That is, the first thing he has to do is to take the immediate custody and control of all the assets of the corporate debtor, including all the business records that is available. Next, he has to represent and act on behalf of the corporate debtor with the third parties and exercise the rights for the benefit of the corporate debtor in any judicial, quasi-judicial, or arbitration proceedings. Yeah, so now the RP also has to raise interim finances, which obviously has to be approved by the committee of the COC. Then the RP is also required to appoint accountants, legals, and other professionals as specified. The RP has to regularly maintain an updated list of claims. Then he has to convene at regular intervals. The RP has to convene the committee of creditors meetings. The RP has to prepare information memorandum that contains all the relevant information of the company. And then the major duty of the RP is that he also has to publish invitation of expressions, that is the EOI, inviting prospective resolution applicants who fulfill the criteria, which is approved by the COC in regard to submission of their resolution plans. So once the plans are submitted by the prospective resolution applicants, the role of the resolution professional is to submit the plans before the COC after checking that the plan so submitted is compliant with the provisions of the code. The RP is also required to file PUFE transaction applications, that is also known as the avoidance transactions, and the RP is authorized to do any other actions on behalf of the corporate debtor, which is mandatory. Yeah, so now section 33(7).
Okay. So we come to section 33(7). The order for the liquidation under this section shall be deemed to be a notice of discharge to the officers, employees, and workmen of the CD, except when the business of the CD is continued during the liquidation process by the liquidator. Section 36(4), which covers the aspects of the liquidation estate, include: the following shall not be included in the liquidation estate assets and shall not be used for recovery in the liquidation. One is the assets owned by a third party, which are in possession of the CD, including the assets held in trust for any third party, bailment contracts. This is important, on which the reliance has been made, all sums due to any workman or employee from the Provident Fund, the Pension Fund, and the Gratuity Fund. So we see clearly that how, the legislature has always protected the rights of the workmen and employees. It has been covered categorically under section 36(4), which includes the explanation of the liquidation estate, that any sums which are due to any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund are to be excluded and shall not form part of the liquidation estate and will not be available to the liquidator. Any other contractual arrangements which do not stipulate transfer of title but only use of the assets, and such other assets as may be notified by the central government in consultation with any financial sector regulator, Assets and security collateral held by financial services providers and are subject to netting and set off in multilateral trading or clearing transactions. Personal assets of any shareholder or partner of a CD, as the case may be, provided such assets are not held on account of avoidance transactions that may be avoided under this chapter. Assets of any Indian or foreign subsidiary of the CD or any other assets as may be specified by the board, including assets which could be subject to set off on account of mutual dealings between the CD and any creditor. So these are the assets which have been excluded under section 36(4) from the liquidation estate. We come further to section 53, where the distribution of assets has been completely explained, notwithstanding anything to the contrary contained in any law enacted by the Parliament or any state legislature. The proceeds from the sale of the liquidation assets shall be distributed in the following order of priority, and within such period and in such manner as may be specified. A is the insolvency resolution process costs and liquidation costs paid in full. So this is the whole discussion which is about, and this is the whole which dispute is all about, whether they would form part of 53(1)(a), where these costs would be paid in full, or B, 53(1)(b), which says that the following debts which shall rank equally between and among the following, which is the workman's dues for the period of 24 months preceding the liquidation commencement date, and the debts owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out in section 52. So 53(1)(a) is full, whereas 53(1)(b) is a pari passu between the workman's dues and the secured creditors who have relinquished security. 53(1)(c) further goes on with wages and any unpaid dues owed to any employees other than workmen for the period of 12 months preceding the liquidation commencement date, and D, which is financial debts owed to unsecured creditors. 53(1)(e), the following dues shall rank equally between and among the following: any amount due to the central government and state government, including the amount to be received on account of Consolidated Fund of India or state, in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date. Debts owed to a secured creditor for any amount unpaid following the enforcement of security interest, any remaining debts and dues. G is preference shareholders, and H is equity shareholders or partners, as the case may be. So this is the whole distribution mechanism as given by under section 53. 53(2) goes on further to say any contractual arrangements between under subsection 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. 53(3) further says the fees payable to the liquidator shall be deducted proportionately from the proceeds payable to each class of recipients under subsection 1, and proceeds to the relevant recipient shall be distributed after such deduction. So 53(1)(a) is the only one where the workmen and employees would get a full amount. The others would be deducted as under section 53. So for the purposes of this section 23(1), it is hereby clarified that at each stage of the distribution of the proceeds in respect of a class of recipients that rank equally, each of the debts will either be paid in full or will be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. And the term workman's dues shall have the same meaning as assigned to it in section 326 of the Companies Act. Under the Companies Act 1956, section 59A provided that workmen's dues and debts due to the secured creditors in terms of section 529A(1)(c) shall be paid in priority to other debts. Further, it provided that in case of insolvent companies, winding up should be undertaken in terms of laws of insolvency with respect to the status of the persons adjudged insolvent. So now when we come to the legislative history with respect to the workmen and employees towards the wages and salaries, we come to, we'll just come and understand through various provisions that the entire legislative history has given special reference and has given special provisions to the dues to the workmen and employees, and has ensured that a very fair treatment is given to all the dues of the workmen and employees, and that they are paid appropriately. We come to the provision to section 59(1) of the 1956 Act provided that the workman shall deem to have pari passu charge in his favor to the extent of workman's portion, It further stated that where the secured creditor, instead of relinquishing, is enforcing his security, the debt due to the extent of the workman's share in the security shall rank pari passu with workman's dues for the purposes of section 529A. So as we see in the IBC, we can see the same provisions appearing under section 59(1) and with section 529A, where once again the workmen's interests were protected. The said section was brought in by way of the Companies Amendment Bill 1985 with the objective to introduce necessary legislation for the legitimate dues of the workers, ranking pari passu with the secured creditors in the event of the closure of the company. So the objective here was that in the unfortunate event of the liquidation, workers whose labor and effort constitute an invisible but easily perceivable part of the capital of the company are not deprived of their legitimate right to participate in the product of their labor and effort. So this aspect being brought about clearly in all the legislatures earlier, even prior to IBC, is what has been brought about here by Honorable Supreme Court. Again, it was mentioned about section 530 of the 1956 Act, where the waterfall mechanism, as per which the priority to be given to different kinds of debts. Subsequently, the Companies Bill 2009 and 11 were introduced, wherein the wages and salaries payable to workmen for a period of 2 years were protected in case of winding up the company. So the 2 years wages and salaries were again protected by section 530 of the 1956 Act. Thereafter, under the Companies Act 2013, section 326 and 327, overriding preferential payment and preferential payments were introduced, wherein a provision to section 326 was inserted. So once again, we see in various provisions that the rights of the workers were protected. Further, in section 325, after this IBC code was promulgated in 2016, section 325 was omitted with effect from 15th of November 2016. On enactment of the IB code, the winding up proceedings in the case of insolvency are to be governed by the provisions of the IB code, and the provisions of the IB code only shall be applicable to deal with the winding up proceedings, as the IB code is a complete code in itself. Thereafter, an amendment with effect from 15th of November 2016 has been brought under section 327(7) of 2013 Act, wherein it has been clarified that the provisions of section 327 and 326 of the Act will not be applicable in the event under the liquidation under the IBC code. In case of any insolvency in a winding up of a company, under section 326 and 327 of the Companies Act, the workman dues are to be paid as under. Workman's portion in the security shall be paid in priority to all the other debts. However, the workman dues given in B1 and 2, payable for a period of 24 months, shall be paid in priority to all the other debts, including debts due to secured creditors. This means that the wages and salaries for a period of 24 months is over and above every other claim or debts, including debts due to secured creditors. Workmen's dues include Provident Fund, Pension Fund, and Gratuity Fund, or any other fund for the welfare of the workmen maintained by the company. Under the IB code, the workmen dues have been duly protected, and the Provident Fund, Gratuity Fund, and Pension Fund have been excluded from the liquidation estate assets, as we have just discussed under section 36(4) of the IB code. As per section 53 of the IB code, the workmen dues are given top priority in the waterfall mechanism. Do we have any questions up till now, Shala? Shala, do we have any questions up till now?
No, ma'am, no questions till now.
Okay, we'll continue. Now, the issue of giving priority to the workmen dues have been considered time and again in the various committees' reports. In the Bankruptcy Law Reforms Committee, Volume 1, it was agreed that the assets held in by the entity in trust, such as the employee pensions, assets held as collateral to certain financial market institutions, and assets held as part of operational transactions, where the entity has right over the asset but is not the owner of the same, shall be excluded from the liquidation estate. Furthermore, it was also debated with respect to the waterfall mechanism under the code, and was agreed that the workman dues capped up to 3 months will be given in the second priority with the secured creditors after the costs of the corporate insolvency, CIRP, and liquidation. Subsequently, a report of the Joint Committee on the IBC 2015 was prepared and presented in Lok Sabha on 28th of April 2016, wherein the issue of this exclusion of the Provident Fund, Pension Fund, and Gratuity Fund from the liquidation estate assets and estate of the bankrupt was debated. After an in-depth examination, the committee was of the view that the Provident Fund, Pension Fund, and Gratuity Fund, which provide the social safety net to the workmen and employees, and hence need to be secured in the event of liquidation of a company or bankruptcy of a partnership firm. The committee further observed that the workers are the nerve center of any company, and in the event of any company becoming insolvent or bankrupt, the workmen get affected adversely, and therefore priority must be given to their outstanding dues. Therefore, all the sums due to any workman or employee from the Provident Fund, Gratuity Fund, or Pension Fund should not be included in the liquidation estate assets. Thus, to protect the interest of the workmen, the committee decided that the workmen dues for a period of 12 months, as provided under Section 53, could be increased to 24 months preceding the liquidation commencement date. So this was how the Section 53 was devised after an internal debate within the committee. And they had come to the conclusion that the workmen's dues up to 24 months preceding the liquidation commencement date should form part of distribution under Section 53. And in light of the same, Section 36 of the Code has clearly given outright protection to the workmen's dues under Provident Fund, Pension Fund, and Gratuity Fund, which is not treated as liquidation assets, and the liquidator has no claim over such funds. Therefore, this share of workmen's dues has consciously been taken outside the liquidation process. In light of the above statutory provisions under the IB Code and the legislative history, the claims of the workmen employees towards wages and salaries prior to the CIRP and during the CIRP are required to be considered. So the Honorable Supreme Court further gave on to say that it cannot be disputed that as per Section 513 of the IB Code, the insolvency resolution process costs shall include any costs incurred by the RP in running the business of the CD as a going concern. It is also true that Section 20 of the IB Code mandates that the IRP is to manage the operations of the CD as a going concern, and in case during the CIRP, the corporate debtor was a going concern, the wages and salaries of such workmen or employees who have actually worked shall be included in the CIRP costs. And in case of liquidation of the CD, dues towards the wages and salaries of such workmen who actually worked when the CD was a going concern during the CIRP, being a part of the CIRP costs, are entitled to have the first priority, and they have to be paid in full as per Section 53(1)(a) of the IB Code. Therefore, while considering the claims of the concerned workmen and employees towards the wages, first of all, it has to be established and proved that during the CIRP, the CD was a going concern. And number two, that the concerned workmen or employees have actually worked while the CD was a going concern. The wages and salaries of all the other workmen who during the CIRP who actually have not worked or performed their duties when the CD was a going concern shall not be included automatically in the CIRP costs. And only with respect to those workmen or employees who actually worked during CIRP while it was a going concern are to be included in the CIRP cost and shall be paid in full as per Section 53(1)(a). Any other dues towards the wages and salaries of the employees or workmen shall have to be governed by Section 53(1)(b) and 53(1)(c) of the IB Code. Any other interpretation would lead to absurd consequences and violate the scheme of Section 53, read with Section 513 of the IB Code. So this was the judgment delivered by Honorable Supreme Court, which clearly mandates that only the employees and the workmen who have actually worked during the CIRP period, and also that the CD was a going concern during the CIRP period, when these two things are established, only such employees' salaries would form part of the CIRP costs and would be paid under Section 53(1)(a) in full. If any other interpretation, more particularly the interpretation canvassed on behalf of the appellants, is accepted, in that case, the wages or salaries of those workmen or employees who have not worked at all during the CIRP shall have to be treated or included in the CIRP costs, which cannot be the intention of the legislature. On a fair reading of Section 513 of the IB Code, which defines IRP costs, it is observed and held that the dues towards the wages and salaries of only those workmen or employees who actually worked during the CIRP are to be included in the CIRP costs. The rests, as observed, shall be governed by sections 53(1)(b) and (c) of the IB Code. In the present case, the RP or the liquidator has seriously disputed that during the CIRP, the CD was a going concern. It is seriously disputed that the respective appellants, workmen and employees employed at the Dahej Yard and Mumbai head office actually worked during the CIRP. So it is true that while submitting the claims towards CIRP costs, the RP has not submitted the claims towards the wages and salaries. However, still the claim to be submitted by the appellants will have to be adjudicated upon and considered by the liquidator, and the liquidator has to adjudicate and consider two things: whether the corporate debtor was a going concern during CIRP and how many workmen or employees actually worked during CIRP while the CD was a going concern. If during the adjudication of the claims made by the respective workmen, it is established and proved that during CIRP, the CD was a going concern and they had actually worked, such workmen and employees, they had actually worked, then the wages and salaries of such workmen or employees are to be included as CIRP costs as defined under Section 513, and they will have to be paid in full as per Section 53(1)(a) before making any other payments as per priorities mentioned in Section 53(1). Now, so far as the submission on behalf of the appellants, that as per Section 20, this is another important aspect. As per Section 20 of the IB Code and even as per the decisions in Swiss Ribbons versus and the Gujarat Urja Vikas Nigam Limited, the RP is under mandate to manage the operations of the CD as a going concern, and therefore it is to be believed that during the CIRP, the CD was a going concern. Managed or operated as a going concern cannot be accepted. It is true that under Section 20 of the IB Code, it is the duty of the RP to manage and run the operations of the CD as a going concern. However, the words used under Section 20 are that the IRP shall make every endeavor to manage the operations of the CD as a going concern. So here the word every endeavor is important. Even if it is found that the CD was not a going concern during the CIRP, despite the best efforts by the RP, it cannot be presumed that still the CD was a going concern during the CIRP period. Section 20 has clearly mandated that the IRP or the RP has to make every endeavor to ensure and manage the operations of the CD as a going concern and ensure that the CD is kept as a going concern. It depends upon the circumstances of each case. And in this given case, the CD may be a going concern or it may be not a going concern. Therefore, the submission on behalf of the appellants that as the RP is under mandate to manage the operations of the CD as a going concern under Section 20 of the IB Code, and therefore it is presumed that the RP manage the operations of the CD as a going concern, and therefore the workmen or employees are entitled to their wages and salaries during the CIRP to be included in the CIRP cannot be accepted. However, the wages and salaries will have to be paid as per the priorities maintained in Section 53(1)(b) of the code. I think someone has raised hand, but we'll discuss after we finish this part. The dues of the workmen and employees towards Provident Fund, Gratuity Fund, and Pension Fund. The Supreme Court has further delivered in the judgment where it says that now so far as the dues of the workmen or employees on account of Provident Fund, Gratuity Fund, and Pension Fund are concerned, they shall be governed by Section 36(4) of the IB Code. 36(4)(3) of the IB Code specifically excludes all sums due to any workmen or employees from the Provident Fund, Pension Fund, and Gratuity Fund from the ambit of liquidation estate assets. Therefore, Section 53(1) of the IB Code shall not be applicable to such dues which are to be treated outside the liquidation process and liquidation estate assets under the IB Code. Thus, Section 36(4) has clearly given outright protection to workmen's dues under Provident Fund, Gratuity Fund, and Pension Fund, which are not to be treated as liquidation estate assets, and the liquidator shall have no claim over such dues. Therefore, the concerned workmen or employees shall be entitled to Provident Fund, Gratuity Fund, and Pension Fund from such funds which are specifically kept out of liquidation estate assets And as per section 36(4), they are not to be treated, not to be used for recovery in the liquidation. In view of the above and for the reasons stated above, it is held as under that the wages and salaries of the workmen and employees of the CD for the period during CIRP can be included, provided it is established and proved that the IRP or the RP managed the operations of the CD as a going concern during the CIRP and that the concerned employees or workmen have actually worked during the CIRP, and in such an eventuality, the wages and salaries of who have actually worked during CIRP shall be treated considering as part of CIRP cost and be paid in full under section 53(1)(a). Considering section 36(4) of the IB Code, when the Provident Fund, Gratuity Fund, and Pension Fund are kept outside the liquidation estate assets, the share of those workmen dues shall be kept outside the liquidation process, and the concerned workmen or employees shall have to be paid the same amount out of such Provident Fund, Gratuity Fund, and Pension Fund, if any available, and the liquidator shall not have any claim over such funds. Now, there are disputed questions whether in fact the IRP or RP managed the operations of the CD as a going concern during the CIRP, and there is a serious dispute whether Dahej Yard was operational during the CIRP or not, and there is a serious dispute that the concerned workmen or employees of the Dahej Yard and the concerned employees of the Mumbai head office actually worked during the CIRP or not. Therefore, it is directed that the appellants submit their claims before the liquidator and establish proof that during CIRP, the IRP or RP managed the operations as a going concern, and that they actually worked during CIRP, and the liquidator is directed to adjudicate such claims in accordance with the law and on its own merits and on the basis of the evidence which may be laid or produced, irrespective of the fact whether the RP, who himself is now the liquidator, included the claims of the appellants being wages and salaries during CIRP as CIRP costs or not. The liquidator is directed to adjudicate such claims independently. And if it is found, in fact, that the RP managed the operations of the CD as a going concern during the CIRP and the concerned workmen actually worked during CIRP, their salaries should be considered included in CIRP costs, and they will be paid as per section 53(1)(a) of the IB Code in full before distributing the amount in priorities as mentioned in section 53. This exercise shall be completed within a period of 12 weeks from the day of the judgment, and such amount shall be paid out of the amount which is directed to be kept aside earlier by the adjudicating authority and thereafter by this court. Till such claims are adjudicated upon, the liquidator is directed to keep aside the said amount exclusively to be used for the workmen or employees' dues, which is to be paid on adjudication as above. So we have just concluded and discussed in detail the judgment delivered by Honorable Supreme Court. I saw some hands being raised or some questions, so we can discuss in case there are any questions.
Ma'am, there's a question, but this is not with regard to this particular case. This is with regard to the Sudaresh Bhatt ABJ Shipyard case with regard to the Customs Department. So should I read that one? Because this
maybe we can answer. Yeah, it doesn't relate to this part.
Yeah,
so we can answer that separately.
Yeah, sure.
Any other question? There are two participants raising hands. First, let's consider them.
So you have to write your questions in the Q&A part to the participants who have raised their hands.
Please, you are requested to write your questions so that we can answer them. There are 4 participants raising hands. So may I request you to please write your questions. Are there any questions?
Yeah, so we have received one question. The question is, was the Moser Bear case cited for settlement of workmen dues?
Not
So
in this particular judgment as
yeah,
such.
in this particular judgment, in the Mosabeh case, the issue was regard to the pension and gratuity, but here the main issue was whether the workmen were actually working during the CRP period or not. So the court has not gone into depth with regard to the PF and pension. They have just relied that Section 36(4) does not, in Section 36(4), in the liquidation estate, the pension and PF, gratuity, everything is excluded. Apart from this, they have not gone into the Mosabeh case.
This particular judgment is with regard to the claims which are generally filed by all the workmen and employees who claim to be claiming a full salary during the CIRP period, irrespective of whether the company was kept as a going concern or not. So this judgment is particularly with regard to that, which has, I think, very clearly been brought about by the Honorable Supreme Court and given a judgment, which very clearly gives out now how the claims of the workmen and employees have to be dealt with by the liquidator or the RP. So I see about 5. Yes, this question says whether the workmen are entitled for wages till the date of the liquidation order. Well, in case they have worked, yes, till the liquidation order, in case they have been part of the working, then they will be paid in full, like we've just discussed in the CIRP period. In case they have not been a part of the working of the going concern of the CD, then they shall be paid as per section 53, 1B and C.
So there is another question which states, the question is that the corporate debtor has to be presumed to be going concern since the resolution plans can be for the going concerns only and also during liquidation. There are provisions for sale of corporate debtor as going concern. Therefore, the decision of Supreme Court directing the verify that the CD was going concern or not is not relevant.
This has been delivered by the Honorable Supreme Court, considering that we just went through that section 20, which says that the RP or the IRP would make every endeavor to keep the company as a going concern. However, there may be circumstances when, irrespective of all the efforts made by the RP or the liquidator, the company cannot be maintained as a going concern. So under such circumstances, it cannot be said that the company is mandatorily a going concern and that all the wages and the salaries due to all the workmen and employees should be paid in full. So that aspect has been brought about, saying that in case the company has not been brought about as a going concern, then these may not be paid in full. I hope that answers the question.
So the next question is that even if one unit of the corporate debtor is not functional and all others are working, can it be said that the corporate debtor is a going concern that is managed by the RP?
Once again, it has been very clearly brought about in the judgment that the liquidator has to adjudicate upon each case whether that particular unit was kept as a going concern, and even if it was kept as a going concern, whether that particular employee or workman was actually participating in the working of the company. If these two aspects are established, it could be possible that maybe one unit is kept as a going concern. If these two aspects are established, only then will the dues of such workman or employee form part of the CIRP cost and would be paid in full. Otherwise, it would be forming part of section 53, 1B and C. Yes, there is a question which says if there may be liabilities for PF, gratuity and pension fund, but there are no corresponding assets as these are liabilities are not funded. In that situation, the question of exclusion from liquidation estate may not arise. Yes, that is right. Then if there is no fund available, then it is not, then the question of inclusion or exclusion does not arise. There is a question which says that the employees and workmen are automatically discharged from their services at the beginning of the liquidation order. Please elaborate. So it is clearly mentioned that the liquidation order is an order for a notice. It is considered as a notice of discharge to all employees and workmen from the work, unless the company is kept as a going concern even during liquidation order, and the such employees and workmen are required to be working during that time. Unless these two things are established, it is considered an automatic discharge notice to all the employees and workmen on the date of the liquidation.
Yeah, just to add in this section, the relevant section is section 33, clause 7. So as ma'am just told, if the company is run as a going concern, even during the liquidation, the provisions as to how the employees will work and how the company will go about, that is clearly mentioned in the NCLT's order.
This question which says that the workers, if the workers had worked during CIRP for a few days and then left the job, will this also apply there? Yes, if they have worked and it is established that they were a part of the working of the going concern and that the CD was kept as a going concern, then they should be paid as per, they will obviously form part of the CIRP costs then, even if they've quit their job in between. For whatever period they have worked, and whatever salary or wages due to them, they would be paid. I think there are a few questions which relate to that Moser Bear. I think we can have a separate discussion, or maybe, we can bring about this case in one of the next discussion meetings.
Yeah, sure, we can do it. And ma'am, I think we have covered almost all the questions.
Yes, I think so. So thank you all. I thank you all for today being here on such an important day, which is 31st of December. And I wish you all a very happy new year and a very prosperous year to all the friends. Thank you.
Okay, thank you.
Thank you.